Guys, I want to talk to you today about the notwithstanding clause and about what we at the Canadian Constitution Foundation have called the constitutional storm brewing about this provision of the Charter. There's a lot of confusion about what the notwithstanding clause actually does, as well as the implications of using it. And the reason that we're talking about this right now is because Conservative leader Pierre Poilievre announced this week that he would like to use the notwithstanding clause as part of his agenda on crime, specifically to allow the stacking of parole ineligibility periods. People refer to this as the stacking of life sentences. It's actually the stacking of parole ineligibility. And this would be a parliamentary response through legislation to a Supreme Court case called Bissonnette, where the Supreme Court found that this stacking of parole ineligibility for a mass murderer in that case was cruel and unusual punishment under Section 12 of the Charter, because it would mean Alexander Bissonnette, this mass murderer, would be ineligible for parole for 40 years in that case, but up to 150 years. Now, because of this Supreme Court decision, Mr. Bissonnette, who murdered 6 people who were praying at a mosque, he will now be eligible for parole after 25 years. Personally, I think that the Supreme Court got it wrong in this decision. I fundamentally disagree with the Bissonnette case. I'm not alone. Many Canadians think that brutally gunning down and murdering 6 people who are praying deserves a sentence like the one Bissonnette originally received, or even longer. For many people, 40 years is not enough. And it seems like the Conservative leader, Pierre Poilievre, he agrees with that position as well. So he announced that he would use the notwithstanding clause, Section 33 of the Charter, to reintroduce the law that the Supreme Court struck down. So he would impose consecutive parole ineligibility periods. Now, Section 33, the notwithstanding clause, is part of our Constitution, obviously, but it has never been invoked by the federal government. So what's the deal with Section 33? How can it be used? What does it mean? I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the Litigation Director with the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada, like this one. So if that's something you think you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. It will mean more people will see them if you hit that like button and if you hit the subscribe button. So please help me out by subscribing. Also, please remember, nothing in my videos is ever legal advice. If you have your own legal question or problem, please consult your own lawyer. So I told you the reason we're talking about the notwithstanding clause again, because Pierre Poilievre said he'd like to use it to stack this parole ineligibility because the Supreme Court struck down the law that permitted the stacking in that case of R and Bissonnette. So let me tell you about that case, the Bissonnette case. We'll look at the facts of the case. Back in 2017, Alexandre Bissonnette entered the prayer hall of a mosque in Quebec City and he opened fire. He shot for 2 minutes, killing 6 people and seriously injuring 5 more. It is one of the worst mass shootings in our country's history. It was motivated by hatred. And it was a terrible, terrible, unforgivable crime. Bissonnette went on the run for about 20 minutes, then he called 911 and turned himself into police, and he actually pled guilty in the case. The Crown, the government, they asked for consecutive sentences for all 6 murders. So that would have mean Bissonnette would be ineligible for parole for 150 years. And the law at the time permitted the judge to do that. But the judge said 150 years was excessive, but the crimes were so terrible that it deserved more than the baseline of 25 years of parole ineligibility. So ultimately, Bissonnette was given 40 years without parole. But the Supreme Court said that even 40 years would be cruel and unusual punishment and was prohibited by Section 12 of the Charter. So now Bissonnette is going to be eligible for parole after 25 years. Honestly, in my opinion, 40 years is not enough. but the Supreme Court said that it would be cruel and unusual. The court said that such a punishment is intrinsically at odds with human dignity because it presupposes that an offender is beyond redemption and lacks the moral autonomy to rehabilitate themselves. The court also emphasized the psychological effects of a sentence like 40 years or 150 years. They held that offenders deprived of any opportunity of release have no incentive to improve themselves and live a futile existence. The court noted what they called the crushing psychological effect of being isolated from loved ones and from the outside world, while knowing that nothing you could ever do would let you break that isolation. Here, I might note how the families of the victims of the people that Bissonnette murdered might feel about the inability to break their grief and the loss that he subjected them to. But I digress. The Supreme Court also noted that many offenders who are faced with this predicament, where they will never get out of prison, it can cause them to become suicidal as a way of breaking what they describe as this suffering. And the court held that these effects further support the conclusion that a sentence of life imprisonment without the possibility of parole is fundamentally incompatible with human dignity. So they concluded, they struck down that law that allowed the stacking of parole eligibility, and Mr. Bissonnette will be eligible for parole after serving 25 years of his sentence. Now, we're often told that the ability to apply for parole doesn't mean you get parole. You hear this as a counter in the media a lot when people bring up the Bissonnette decision. But it's also important to remember that there actually are many examples of mass murderers in Canada who have received parole. For example, serial killer Marcelo Palma shot 3 sex workers and he was granted full parole after 27 years. Roger Warren murdered 9 gold miners in the Northwest Territories in 1992, and he got full parole after 25 years. And Dennis Lordy, who stormed the Quebec National Assembly with 2 submachine guns and murdered 3 staff members, he got parole after 10 years. So I'm pretty skeptical when the response to the Bissonnette case is, but he won't get parole anyway, so you don't need to worry, because serial killers in this country actually do get paroled. So it is something that we need to worry about. Now, the Bissonnette decision was really unpopular. I'm interested in what you guys think of the issue. What do you think? Leave a comment below. Personally, look, I admit I am not what you call a tough on crime lawyer or a law and order type person. I'm a civil libertarian. I'm generally quite skeptical of police and government power. I'm skeptical of the carceral system. But that said, I think that Bissonnette, that decision is absolutely bonkers. I think that it's completely justifiable to keep him in prison for 40 years. I mean, the conclusion to me, even as a skeptic of police and state power, it just does not make any sense. But let me know what you think. Leave a comment below. So I told you what I think, but what's interesting here is we all know what Pierre Poilievre thinks. He thinks that the 40 years was completely justifiable. He thinks 25 years was the wrong decision. He said that he would invoke Section 33 to reintroduce legislation that was struck down in that Bissonnette case. So let's talk about Section 33 because there's a lot of misunderstanding about it. So first of all, Section 33 is part of the Charter. I will put the text up here on the screen so you can read it. But to paraphrase, it says that Parliament or a provincial legislature may pass a law that will operate notwithstanding the rights in Sections 2 and 7 through 15 of the Charter. And that these declarations last for 5 years and then they can be reenacted. So you can see there are a bunch of internal limits in Section 33. It needs to be expressly declared. It can't be implied. And it only applies to certain rights. So Section 2, which are fundamental freedoms, including freedom of expression, religion, thought, belief, opinion, assembly, and association. It applies to Section 7, which is life, liberty, and security. Section 8, which is freedom from unreasonable search. Section 9, which is freedom from arbitrary detention. Section 10, which is your rights on arrest. Section 11, which are your procedural rights once charged with an offense, like the right to be presumed innocent and the right to a trial within a reasonable time. It applies to Section 12, cruel and unusual punishment, which is the right at issue in the Bissonnette case. It applies to Section 13, which is the prohibition on self-incrimination, Section 14, the right to an interpreter, and Section 15, which are equality rights, so the right to be free from discrimination. So it's not a blank check. It can't be used for voting rights in Section 3 of the Charter, to change the constitutional standards around an election, which is in Section 4, or the sitting of Parliament in Section 5. It can't be used for mobility rights, like the right to enter, remain in, and leave Canada. And of course, it needs to be renewed every 5 years. Now, I also want to respond to a few ways that we see the notwithstanding clause described. So some people in the media say that Section 33 allows the government to violate the Constitution or constitutional rights. This is not an accurate way of characterizing the notwithstanding clause. It is part of the Constitution, so it can't be unconstitutional. In fact, we would never have had a charter if there was no Section 33. The inclusion of Section 33 was a fundamental part of what made the bargain of the charter possible, because before the charter was finalized, a number of premiers were expressing concerns that the wide-ranging protections in the charter might give the judiciary, the courts, too much power to invalidate provincial laws. They worried that the charter could lead to a situation where provincial legislatures were unable to implement policies that they thought were necessary, even policies that are supported by a majority of the population. So the inclusion of Section 33 was part of what made the bargain of the charter possible. Another way that Section 33 gets characterized that I think is incorrect is that it's often called an override clause, or that is used to override rights. Now, I think this is just a turn of phrase because it's easy to understand, but it isn't actually how it often works. It's not quite correct. So I don't think that it should be called an override. Basically, it allows laws to operate notwithstanding those provisions of the charter. It doesn't use the phrase override. And in many cases, it's actually about a dispute between the courts and the Parliament over what is protected or how it should be protected. The legislature might have a different interpretation of rights than the court has, and the legislature, they do have a role in defining rights. This is how it was used in a number of provincial cases to allow the legislature to have a role in defining the scope of a right or how it can protect that right when the legislature has a different interpretation. This might be a little confusing, so I will give you an example. Section 33 was used in a case in Saskatchewan involving Catholic schools. There was a court ruling that potentially jeopardized funding for non-Catholic students who attended Catholic schools. And the Saskatchewan government invoked the notwithstanding clause to protect parents and students' right to choose their school regardless of their religious affiliation. And the goal of the invocation of Section 33 was to ensure that the government funding model remained available to students regardless of their religious affiliation or the school they attended. And the invocation effectively allowed the province to continue its funding model in spite of a court decision that might have upset it, because the government, the legislature, had a different interpretation of the rights of these students and how best to protect them than the courts had. And the use of Section 33 wasn't about overriding any rights. It was about advancing the government's interpretation of them in Saskatchewan. Let me know if that makes sense. But basically, I don't think it should be called an override clause because it's actually more about a conversation about rights between Parliament and the courts in many of these cases where it's used. Now, I do think that there are some cases where Section 33 does actually operate more like an override, even though I don't think that term should be used. So I understand why people use it. I just don't think it's accurate. I'll give you an example of where that might happen. So the Bill 21 case in Quebec, that involves the use of the notwithstanding clause to ban certain public government officials from wearing religious symbols. And the law pretty clearly is not about advancing a different interpretation of rights. Although, hey, maybe Quebec would disagree and say it is advancing the right to state neutrality. I mean, I don't agree. I don't think that's how religious freedom actually works. This is all being debated right now in a case that is going to the Supreme Court called Hack. And actually, the Hack case leads to another really big issue about the debate over the notwithstanding clause. There are some uses of Section 33 that are much more controversial than others because of when it was used. This is an issue in the Hack case that I just mentioned. Basically, the debate is about whether Section 33 can be used before a court gives an opinion on the rights being implicated, or if it can only be used after a court ruling. This is the preemptive use debate. And in Hack, the Quebec government passed the religious symbols law and immediately used Section 33. There was never a court ruling on whether or not the law violated the rights of religious people in Quebec. It's also been used in another case being litigated from Saskatchewan. It's a battle over gender identity and informing parents, parental consent of students who identify with a gender other than their biological sex. So there's a live debate over this issue of preemptive use of Section 33 and whether or not the court can even opine on the law once Section 33 has been invoked. That is one of the most controversial uses of the law. In other cases, like the Catholic schools case, Section 33 was used in response to a court decision. And that's a lot less controversial. And if Pierre Poilievre uses Section 33 to reintroduce the same legislation that the court struck down in Bissonnette, that would be the same. It's a response to a court decision, not a preemptive use. It is the less controversial way of using the notwithstanding clause. Now, another thing that I want to mention is that the media often portrays that there is some sort of expert consensus on the use of Section 33. For example, there are a lot of one-sided articles where experts say how bad it is that Pierre Poilievre wants to use the notwithstanding clause, and these experts, frankly, are generally quite one-sided. There is, in fact, a very lively debate among constitutional scholars about the role of the notwithstanding clause in Canada's constitutional architecture and history. These debates are not reflected in these media stories. There is actually one, though, that does. It's an excellent article by my colleague Joanna Barron that explains this debate over the notwithstanding clause and how it applies to Pierre Poilievre's proposal. I will link to that article below so you can read it for yourself, but I'll also explain it. Basically, Section 33 is part of this big debate between courts and lawmakers about who gets the final say in society-wide dilemmas like crime in this current debate over the Bissonnette decision, but also in other issues like addiction, religion, gender, children, sexuality, all kinds of things. Who gets the final say on rights? And there are scholars who support the use of notwithstanding clause as part of this kind of dialogue between the courts and the legislatures. For example, Jeff Sigalet of University of British Columbia and Dwight Newman from the University of Saskatchewan, they see Section 33 as setting up a dialogue between Parliament and the courts about the extent and content of rights. This is sometimes called the coordinate approach to rights protection, and it maintains the principle of democratic legitimacy as foundational to our constitutional order and sees the use of the notwithstanding clause as an entirely legitimate part of the Constitution. We know, as I said, from the negotiations between provincial premiers leading up to the adoption of the charter, that excluding Section 33 from the final text was going to be a deal breaker. This was particularly the case among the prairie premiers, the premier of Saskatchewan, Alan Blakeney, and the premier of Alberta, Peter Lougheed. Now, under the coordinate approach, the constitutional supremacy clause in Section 52, which says that the law which is contrary to the Constitution of Canada is of no force or effect, it allows for both Parliament and the judiciary to define the scope and meaning of constitutional rights. The rationale for this is that different branches of the state have different capacities and zones of expertise. For example, judges are best positioned to engage in legal analysis and apply precedent to specific factual scenarios before them, while parliamentarians are representative of their constituencies and democratic preferences. Under this view, legislative use of the notwithstanding clause is less about a curtailment of rights than a different balancing of rights or different interpretation of the requirement of charter guarantees that were drafted really broadly on purpose. So when applied to the Bissonnette case, what does the right to be free from cruel and unusual punishment, as guaranteed under Section 12 of the Charter, actually require? Surely as a national community, there's relative consensus that it protects against torture or deprivation of the essentials of life and maybe capital punishment as well. But what about stacking sentences so that you're ineligible for parole for 150 years or 40 years? Is 25 years the only acceptable sentence without it being cruel? Clearly, lawmakers and the courts disagree about this issue. But the Globe and Mail characterized this as arbitrary and a shortcut, and that it would preempt judicial oversight. I mean, actually, no. We know that the court already opined on this very issue in Bissonnette, so it's not a preemptive case. But the Globe and Mail nevertheless said this is a potential abuse of power, and it said that it allows the government to override rights that go to the heart of an 800-year battle dating back to the Magna Carta. This is almost hysterical and overstating things to a really misleading degree. I mean, the Magna Carta never suggested that there is a right to a chance at parole after 25 years after committing mass murder. There are just different interpretations of the right between courts and parliament. And from Poilievre's point of view, 25 years is just not enough time. And this view, frankly, is closer in proximity to regular Canadians than the position of these cloistered judges at the Supreme Court. The need of the community to express moral denunciation through a lifelong prison sentence must be counterbalanced against the abstract rigors of charter jurisprudence conducted by a wise, but sometimes frankly out of touch group of elite judges. It's not a strange position to hold, the one that I have, the one that Pierre Poilievre has, that 25 years is not enough time. There was an article written in The Spectator by Professor Yuan Yizu, where he wrote that had the judges of the Supreme Court spoken to an actual member of the Canadian public, they might well have found that the average person in the street understands why a murderer can be given a 150-year sentence, let alone 40 years. Now, of course, there are critics of the use of the notwithstanding clause, and frankly, there are cases where it is invoked that I think are awful. The Quebec Bill 21 example is one of them. But I think the bigger picture here is actually about the theory, about the use of the notwithstanding clause, not just about the individual instances when it's used. Another criticism of Pierre Poilievre's proposed use of this clause is that it has never been used by the federal government, and that this is breaking the glass on an instrument, inviting its use all the time. And it is true that the notwithstanding clause has never been used by the federal government. It lay dormant outside of Quebec for the first 35 years of the Charter's adoption, but it has kind of come into fashion to it be used in Ontario, Saskatchewan, and New Brunswick in recent years. And I think it's important to consider the question of why. Why are suddenly governments more interested in using the notwithstanding clause? I think it's no coincidence that its use has followed what some see as an ideological shift at the Supreme Court that began in the early 2010s. First, from a posture of relative deference to parliamentary supremacists into what is now a sort of super legislature at the Supreme Court, what some refer to as activist judges who feel empowered to weigh in on highly divisive moral issues that split Canadian society. So, for example, in 1993, the Supreme Court upheld a prohibition on assisted suicide or euthanasia, or what is now called medical assistance in dying. But in 2013, the court said that the prohibition was unconstitutional. There has obviously been a big shift happening at the court. So when people wonder why the notwithstanding clause is now being used more, we should ask ourselves what the legislatures are responding to. I think it should come as no surprise that legislators, that politicians, want to push back on some of these decisions. And in this case, the proposed use of the notwithstanding clause is in response to a judicial decision that is seen by many as bizarre and immoral in the Bissonnette case. This use by Pierre is perceived by many as a healthy rebalancing of the overall state of the system and a reviving of parliamentary supremacy. On the other hand, though, as a skeptic of state authority, I do have some serious reservations about individual cases when Section 33 is used, like Bill 21, even if its use is constitutionally legitimate. And I, of course, also have concerns about the preemptive use of the clause broadly, although, of course, that more controversial use case is not what is being proposed by Poilievre here. It is, though, what's being actively litigated in the Hack case. So that is the lay of the land on Section 33 and the debate over it. Contrary to what you hear in the media, there is actually no expert consensus, and there is in fact a very live debate and a really interesting one. So I'm really curious what you think about Section 33. What do you think of its use? Does it depend on how it is used? And when do you think it would be acceptable to be used, if at all? Let me know in the comments below. And by the way, that Hack decision from Quebec that's headed to the Supreme Court, we at the Canadian Constitution Foundation will be applying for leave to intervene in that case. So if you want to hear more about that case, make sure that you are signed up as a subscriber for the channel, but also to our email freedom updates at the ccf.ca/freedom updates, so you get notified when we find out if we've been granted leave in Hack. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.